Thank you everyone for coming to this session. It is going to be I guess this might be our first one for the start of the year, actually. And wanted to introduce everyone. We have Michelle Atkins and Joe Gardner from Favros, and Matthew McCauley and Levi Larson from the new firm of Larson Health Advocates, and Beth Cooper and Nancy Nucci. So Beth with PI and Nancy with Coveris. So ready to start talking about this Brown versus OMC case that was a jury trial in Clallam County, and I will let Michelle give an overview of the case first.
Great.
Michelle, all you.
Thanks, Noah. I appreciate it. So for those of you I haven't met before, I am Michelle Atkins. And along with Joe Gardner from Favros Law, we defended this case on behalf of a physician assistant by the name of Charles Speed. The case was brought by a plaintiff by the name of Aaron Brown, who had been a patient at Olympic Medical Center in February of 2016. Levi Larson and Matthew McCauley did a fabulous job of defending Olympic Medical Center in the lawsuit. The plaintiff, Mr. Brown, was represented by Lee Tucker, who many of you know to be a Washington-based attorney. Also co-counsel for Mr. Brown was Keith Bruno. He is partners with Nick Rowley, who some of you know or know of. The two of them share a practice down in Southern California. They hold themselves out as having very significant cases that they believe to be of very significant value. So it was interesting. I had not had a case, let alone tried a case against them. So it was, we were excited to have that experience. So I'm going to give you a basic overview of what the case was about, and then talk a little bit about how in the heck we ended up in a in-person live trial during COVID, and then Levi will take it from there. So basic case is plaintiff Aaron Brown presented to Olympic Medical Center in February of 2016. He came to OMC because he was looking for and needing a medical evaluation or a medical clearance so that he could go to outpatient residential detoxification to detoxify from alcohol. He was known to us to have a long history of alcohol use or abuse. He was known to us to have a history of having prior alcohol withdrawals. And he was known to us to have had at least one prior alcohol withdrawal seizure. The plaintiffs alleged that we should have known more about that history because, in fact, Mr. Brown had suffered many prior alcohol withdrawal seizures. But in any event, the plaintiff's claim was that even with the history, just knowing of the one prior seizure, that the standard of care required our providers to admit Mr. Brown to the hospital for inpatient alcohol withdrawal versus discharging him to an outpatient facility, a facility that we knew had no medical providers on site. So despite the allegation, our clients did in fact do the evaluation, and our client, Mr. Speed, determined that Mr. Brown had no acute medical condition. He required no acute medical attention, and that he was very appropriate to be discharged so that he could go to the outpatient detoxification facility. My client, Mr. Speed, prescribed Mr. Brown with medications to be taken at the facility to address his alcohol, what was anticipated to be his alcohol withdrawal symptoms. Unfortunately, once Mr. Brown did arrive and during his stay at the detoxification facility, he did suffer an alcohol withdrawal seizure. He fell during it was disputed what the event was, but the plaintiff certainly alleged, and I think the jury probably ended up believing, that he did suffer an alcohol withdrawal seizure. He fell, he hit his head on the concrete floor. He suffered multiple skull fractures and a subdural hematoma that required multiple surgical interventions at Harborview. I am happy, and our defense just very basically was that we did what Mr. Brown asked us to do, and we did it reasonably. We did do the evaluation. He was appropriately cleared because he did not have any acute medical needs. And we did not have available to us, nor would it have been appropriate for him to receive inpatient alcohol withdrawal treatment at OMC. And the better place for him to go was, in fact, the outpatient facility. Happy to report that we received, at the close of a 4-week trial, a unanimous defense verdict on behalf of all of the defendants. So our clients were thrilled. We were absolutely thrilled for them. And I think we were also surprised and thrilled that we were actually able to get through the 4-week trial and get it all the way to a verdict. So kind of second best for us was the fact that we got it done. I think, woke up every morning worrying about being able to complete the trial. So that was a huge success in and of itself. Just briefly on how we ended up in a in-person trial during COVID. So trial was set for November. It had already been continued on 2 prior occasions. I had a client who was not tolerating litigation well at all. He had not been doing well from the beginning, and it was certainly with each continuance taking more and more of a physical and emotional toll, and understandably so. So I went into that October status conference. We had an October status conference with Judge Brent Baisden in Clallam County. And I went in very motivated to do whatever I could do to convince the court to allow our trial to go forward. And we were pleased because Judge Baisden also expressed a true desire to let our case go forward to trial. In fact, the court, the staff, the judges there had, it sounds like, conferred. And I thought it was really heartening to hear him say, we're trying to take an approach here in Clallam County of how can we get these cases resolved versus why can't we get these cases resolved? So that was music to my ears. I thought, I've got a good audience here. And he says, we've even thought about putting you guys over in the gymnasium in the community center that was right across the street from the courthouse. And we think we can do that. We can get you the jurors, we can get you the staff. I'm available. But the problem, or the roadblock, is we don't think we have, and we can't get the IT, the technology to support your trial. So Levi and I were not in the same space, but I'm sure we had the exact same thought, which was, oh, no. That is not going to stop this trial from going forward, because we had the good fortune of having professional liability insurers that we all knew were also motivated to get the case resolved, and fortunate enough to have the resources to, within reason, be able to get it resolved. And we had the good fortune of knowing someone by the name of Noah Wick, who would have the ability to do this for us. So we said, Judge, don't let that be a roadblock. We are very confident we can take care of it. And he said, okay, I'll give you a week. Come back in a week and give me your proposal, and we'll see what we can do. So we get on the phone to Noah. We say, Noah, we need your help. He goes out to Clallam County. He does a survey of the courthouse and of the gymnasium, puts together a beautiful proposal, very thoughtful and thorough. 1 week later, we're back in front of Judge Baisden. We say, here you go. Shockingly, somewhat, Lee Tucker says, I'll pay for a third of it. And Judge Baisden said, you're off to the races. So I'll let Levi pick it up from there.
Yeah, thanks, Michelle. I'm going to try to share the screen again, everybody, for the PowerPoint. And Noah, do I have the presenter slides right?
Sorry, you need to share the screen first. If you can go to that.
Oh, great. Okay, here we go. Can you see this? Do I have the right side up? Okay.
Yep. And everyone, anyone, if you see the bar that's between the two, you can actually click in the middle and drag it left and right to make one smaller or the other. So
good afternoon. Yeah, thanks, Noah. Good afternoon, everyone. For those of you who don't know me, my name's Levi Larson, and I had the privilege of representing Olympic Medical Center, a public hospital district, as a co-defendant with Michelle. What we're looking at here, this is not a picture from Back to the Future clock tower. It might look like that. This is actually the beautiful courthouse there at Olympic in Clallam County. It's Clallam County Superior Court. This is really not where the Superior Court takes place. There is a communist era architecture behind this beautiful building that is actually kind of a 70s motif. That's where you actually try the cases in Superior Court. But I did want to start by sharing this beautiful photo of Clallam County, the historical court there. It's really quite a beautiful court. To show what Michelle was referring to earlier, the court kind of left it to the parties. There was a pretrial call, and he said, look, if you can assure me that you have the technical capability to facilitate Zoom testimony for your witnesses, and to do that in this community center that is across the street, then as Michelle shared, I will be there as the judge. I can drag my bailiff and the court reporter across the street as well. And so what Noah did was, after we learned from the court administrator we could be in Port Angeles at 7:30, he sent someone on a 0 dark 30. I don't know what time they had to leave, but I met one of Noah's team members, and we went to this Vern Burton Community Center, and Noah's team was very professional in putting together. This is an example, one of several mock-ups that he did for Judge Bastin, showing how we could use this courtroom and turn it into, or this gymnasium and turn it into a courtroom, the courtroom gymnasium. There were a lot of jokes about, playing Michelle and Keith Bruno, opposing counsel at PIG, to resolve the case. They actually had lifted the basketball hoops out of there, so it was just the kind of hardwood floors. But my hat's off to Noah. Some of the technical aspects that we had to assure the judge were, we needed to make sure that the internet capability in the gym itself could support the video feed. And so that was, you would think that would be as simple as just, checking internet connection. But Noah's team had to bring, and Noah, I defer to you on what these are called, but they basically had to make sure to have the internet boosters. They brought in some remote boosters to make sure it could support the video feed. And then I guess we can move into the actual setup. It was a hybrid in more ways than one. A hybrid meaning that we were calling more than half of the witnesses via Zoom. It was also hybrid, at least initially, and that the court, in order to accommodate other voir dire for their continuing criminal docket, wanted us to kind of do an Alpha Bravo, where we would be in the courtroom gymnasium for our voir dire and then part of our trial, but then going back and forth to the actual Superior Court across the street if we got bumped for a criminal voir dire that needed to take place in that larger space. This is a picture of the actual courtroom when it is set up for the voir dire. And no, I don't know if you want to prompt a question to somebody else. Welcome Michelle and Joe and others' thoughts who observed the voir dire on how to actually went in this courtroom setting.
Yeah. Actually, hey Nancy, why don't you say a little bit about how you were able to watch this and participate?
Yeah, so we got on every day, and so we had a live stream, and we could stay on as long as we wanted. So we would see the jurors. The view itself was difficult to see the reactions, of course, from the jury, because they had their masks on and they were so far away. We couldn't see the judge, but we could definitely see the attorneys. The only comment I'll make about I guess it's a forewarning to people, is that the live stream didn't turn off during the lunch break, which meant that the plaintiff's attorney stayed in the room at the time. So I got to overhear his conversations with people they probably did not know we were hearing. But overall, it was a really good way to watch the jury trial unfold, and obviously to good effect.
All right, thanks.
Just on voir dire, I would say that, as you can just imagine from looking at this picture, which is hilarious with the Bernie in it, Levi, that's such a Levi move, make us all laugh. Is that you can tell every, and I'm sure Levi will touch on this. I mean, every part of this trial was disconnected interpersonally more than what we're used to, right? So this is just one great example, because you're in this huge gym, and yes, we can hear everybody because we had great IT, we had good sound for the most part, some feedback issues, but I mean, you're navigating this ginormous room with people that are 6 feet apart, and trying to have a connection with them. And even when it came down to, our jury being obviously a jury of 14, even then with masks and with making sure we're being respectful of social distancing, it just made it harder in every way to try to connect with the jurors.
And Michelle, in what ways was it harder?
Well, I mean, first of all, it's just awkward because you're going, you're trying to be methodical and say, okay, well, I'm going to talk to this side of the room first and then the other. Then, best laid plans, you're, back and forth across. And that just, I think, creates distraction really for everybody. Everybody's behind a mask, so you're obviously losing something just in that. It just, you just don't, you lose that part of the nonverbal communication. You can't keep your flow as much in the voir dire process, when you're trying to go back and forth and connect, and you're talking to people who are, many, many feet away from you. If you're standing 6 feet from the first person in the row and you're talking to the person in the last row, it's just harder. And yet I am a huge advocate for this versus I wouldn't want to, I would choose this over doing a Zoom trial. Let's just put it that way.
Okay. As far as Levi, did you have to prepare for the hybrid trial different than how you prepare for trials prior to the pandemic? And if so, how?
The short answer is yes. I think we prepared differently. I think that we were doing detailed Zoom preparation sessions with our witnesses, and I imagine most attorneys that are kind of on on deck were doing similar detailed preparation sessions. Those were very helpful because then we could get a preview of, is somebody testifying from their basement with bad light and a bad mic. And then we were able to mobilize Noah's team to go in, hair and makeup, we joked, but literally, I mean, go in and kind of encourage some, one of our witnesses was, a full professor at UW, and we had to kind of politely tell him, you can't testify from your basement. You're our key witness. We need to get you in a room with a better background and better lighting. And so Noah's team actually went to his personal home. They arrived masked up. They tactfully moved him up to a better room with better lighting, and actually lent him a laptop that was going to work better, gave him a mic and a video. So I think those are the kind of checklists. We would call them pre-combat checks, pre-combat inspections, to make sure that your witnesses are ready to go. I did want to, before we move away from the voir dire, if I could just add a couple specific thoughts. I know this is open to the public, so if Keith Bruno is actually watching, hello, Keith. I'm going to give you a compliment sandwich. I'm going to start by saying that I thought that Keith Bruno delivered the trial by human voir dire, brutally honest approach, very, very effective. And so to Michelle's comment that it was hard to connect with the jurors, it was hard because you were masked up. And aside to your earlier point, Noah, did we do anything differently for this? I think you want to test your mask. Back to that theme of pre-combat checks. I had a disposable one, and I found that I was able to speak more clearly without it moving down my mouth. I know Michelle was able to find a very nice pink one that served her well throughout trial. She got a couple compliments on that. But I would say if you are, getting ready to do this, practice questioning with the mask on. And if it's kind of falling down your face, you want to address that so you're not continually, lifting the mask up. As to Keith Bruno, I think for those of you that have a Nick Rowley trial, I would recommend getting the book. I would recommend reading the voir dire section closely, and I would recommend doing some thoughtful preparation for voir dire yourself. I think he used this setting, unfamiliar setting, to his advantage. This is a guy with a lot of trial time. It was clear he's coming from the criminal background. He had been on his feet in front of a jury a lot, very comfortable, but he was very self-deprecating and said, I've never done this before. This is my first time wearing a mask in a gym, and I'm nervous, ladies and gentlemen. I'm nervous to talk to you, in this large setting behind this mask. And it was disarming. And then he went right into those football fans, his Bill Walsh first 10 plays of this brutally honest questioning. And he executed it very well. Thanks for letting me backtrack a little bit to those comments about voir dire.
Well, Joe, let me unmute yourself here if you can. What did you notice, or did you notice any difference on how the judge handled voir dire?
Not really. I mean, this wasn't an objection heavy voir dire really. And so the court staff pretty much handled things. I mean, the biggest thing in terms of like logistics for the court was just that this took longer than it would in a courtroom because you had a bailiff who had a microphone who was wiping it with a wipe every time and was walking around the courtroom. And so if somebody on the left of the room wanted to talk versus somebody on the right, there was a long process for walking across the room in order to get, that new person in the microphone. But I don't necessarily think that the judge handled it any differently than he would have if we'd have just had a big group in the gallery of the normal courtroom.
Well, what about Joe? What about the jurors themselves that were coming in, the prospective jurors? Did they feel like they're comfortable being in the setting?
Yeah, I mean, I think we were in a unique situation in the sense that Clallam County has not been a very hard hit place by the COVID-19 pandemic. I mean, I think at the time of the commencement of the trial, there was less than 400 total COVID cases countywide throughout the course of the pandemic. So, I mean, these folks were not scared of this. We didn't get a lot of immediate pushback in questionnaires about fear of of exposure to COVID-19. We had a couple people that I don't even think we had anybody, Michelle and Levi can maybe correct me if I'm wrong, but that, expressed some problems about wearing masks the whole time. Even somebody asked in the chat about how did the jurors connect with each other. I mean, it seemed like everybody was pretty cordial and friendly and connecting with each other quite well, that, from what we could see with people gathering, and this was a trial, unfortunately, with Keith Bruno's situation where we spent a lot of time with the jury outside the room and a lot of time arguing with each other and the judge, where the jury had, sometimes even 2 hours where they were standing outside the courtroom waiting for us. So I think they had plenty of time to connect. I don't think that there was, and these are friends and neighbors in a local kind of small town community. It might have been different in Seattle with people that are a little more fearful of COVID, but it seemed like these people were just kind of doing their civic duty without any concerns, to be honest.
Yeah, I sorry to jump in, but I totally agree with that. I didn't hear any complaints about being there. I was shocked. I was actually anticipating we wouldn't even have enough of a jury pool, that people would not show up and just use COVID as an excuse. And there were plenty of people and they were eager to participate. And Deborah, to logistically answer your question, there's a room outside the gym. So it's a community center. So there's other larger meeting rooms. and they put for deliberations and for well, not for breaks, they mostly just went outside, but because we were blessed with a lot of decent weather during that time period too. But there was a larger meeting room where the jury went to deliberate, and as Joe explained, and I wanted to say earlier when Michelle said we got a unanimous verdict, we got a unanimous verdict in less than a half an hour, thanks to the excellent work of these defense teams. So they didn't have to talk very long, but they stayed socially distanced roughly in this larger meeting room.
And I can't help but capitalize on this, and it looked like maybe this is a good lead into Levi's next slide. But I mean, to highlight how much these jurors didn't seem to be bothered at all by COVID. I don't know if it was Friday or Saturday, right in the middle of our trial, when Inslee comes up with these new restrictions. And you know, Joe, I remember Joe and I were on the ferry on a conference call with, you know, Beth and Nancy and Levi and Matt and who knows who else, just Simon, what are we going to do? What are we going to do? And you know, these jurors aren't going to show up, and, you know, people are going to be worried. What do you know? Come Monday morning at 8:45, all 14 of them are there. Mm-hmm. They are on time, and not one word was mentioned about even questioning whether we would proceed. And we just plugged along.
Levi, do you want to go into a little bit about this slide here?
I do, and I really want to talk about, just to orient everyone to the timeline here. So we did voir dire on Tuesday, and we were able to complete the voir dire in one day. Wednesday, the court had a day off for some reason I can't recall. So no court Wednesday. Thursday, we did opening statements, and those were in the traditional courtroom. And I would say those went off as they normally do. I don't think there was anything really unique about the opening statements other than the video feed, which I think we can put a pin in and come back to the conversation about the video feed. But I think the openings went off quite well. So then that was Thursday, no court on Friday. And then I believe this was either the Saturday or the Sunday. Judge Inslee says no indoor gatherings. And in addition to that, they also shut down the restaurants. So Michelle and I were stuck in Port Angeles. It was a little bit of a bleak environment, you know, being out there alone, afraid, in a expeditionary mindset there, having no restaurants to eat. Reminded me of some of the deployments I've been on. But I digress. Let me get back to the important things. Was we had a strategy call Sunday evening. And we were talking about contingency plans under CR 48. You can stipulate to jurors less than 12. And we were kind of having these conversations of what's our breaking point? Are we willing to tell the judge, you know, if only 11 people show up, are we willing to go forward? And I think we at that point had already lost one of our alternates. So we were down to one alternate. We had 13 jurors, and they all showed up. Monday, and not a word. I mean, we spent, I would say, more than an hour talking through some concerns that never materialized. Although it was an ongoing. I mean, even though none of the jurors voiced a concern that Monday, it was an ongoing concern throughout the trial that we would lose someone. And we have a couple, I don't know if we want to get into the specific examples now, but there were two other medically related kind of three medically related flare-ups during the trial that we can address later.
Yeah, I just want to highlight that of the additional stresses, for me at least, waking up every morning, listening to the news as I was getting ready and hearing what was going on, and thinking every day, is today the day they're going to pull the plug on us? Because quite frankly, we're thinking to ourselves, how is anyone letting us do this? Was hard, because you just kind of every day thought all of this work is going to be for naught. And so staying focused and not letting that distract was hard for me, at least.
So my hat's off to Judge Baston. I think he really had a lot of courage to say, if the jurors are willing to do this, I'll shepherd this process through. And we're very thankful that he was willing to do that. At times, so I think we were into the second or third week of trial. One of the jurors who was, a little more, she had like a walker, was a little older. She had left a note with the bailiff saying, I've got some digestion symptoms. Can we talk about those? And so we brought her in, and Judge Baston kind of started interrogating her to see if she had, COVID symptoms, which I know the constellation is pretty broad. And, we learned that she actually had ate a bag of Doritos before lunch. And so maybe that explained her digestion concerns. And so we were reassured that we weren't going to lose a valuable juror. I think one of the interesting things that we saw was the judge kind of questioning Michelle's physician assistant client, saying, hey, can you weigh in here with your medical expertise, as well as our nurses that were there? And that was a first time for me, having a judge, point to our client saying, hey, can you weigh in, on a real-time kind of diagnosis of, is her, digestion after a lunchtime bag of Doritos COVID related or not?
So I'm going to move on to some other additional questions here. Tell us, Michelle and Levi, both tell us about your opening statement, and how was it different with this being a hybrid trial and everyone wearing masks? Did your approach change at all?
So my approach didn't change at all, other than I knew that I was going to be lacking some aspects of kind of the nonverbal communication through the mask. It's definitely sucks to stand up there for an hour, with, already you've got your nerves going on and all of that, and you're behind a mask and you're, breathing deeply, and everyone can see you breathing deeply, and, and you're a little bit muffled, but otherwise, as Levi said, the openings really were, other than wearing a mask, were as they normally would be.
Great.
Yeah, I think if we want to talk about the video feed, I mean, it was both, I think, a positive in a lot of ways, and there were some negatives and some concerns that we had to talk through. So the positives were, of course, we were in a COVID pandemic time where normally our carriers would be there every day. We would invite, others to come, and we just wanted to have an alternate to having more bodies in the courtroom. Especially, we were originally supposed to be in not the gym the whole time, but the courtroom for some of the time. And so we were trying to limit the number of bodies in the courtroom. And so we came up with the real-time video feed. I think the advantage was that we were able to share it with, kind of a larger audience. I think the disadvantage was that it was open. If we were going to have this feed, it had to be shared with Keith and Lee. And we know, if you guys are listening, hi, I mean, you had the right to share it with your folks as well. We think they did. And so, it was, I think there could be a larger discussion about, is that more of a distraction? Are we willing to have that trade-off? And I think there was also, for one of the days in the courtroom, our trial tech was having to, during the openings, both kind of manage the video feed, and some folks outside of our circles were, connecting the bailiff, the clerk's office, saying, hey, the video is not working. And then the judge is reading the note to us. And he said, hey, look, I'm not your tech support. I'm not going to be stopping anything if your video is not working. And so this is kind of for you guys to figure out. If you want the video and you can figure it out, you can, but I'm not interrupting the court operations if you have difficulties with your video feed. So,
yeah, I think the only thing, if any of you are to be in a similar situation, and I think that this is probably a consideration for Zoom trials too. I don't know what the courts are doing in terms of allowing this to remain a public courtroom. And in our situation, people could have come and been spectators to the trial, but obviously that wasn't happening much for, because people were being safe and cautious. And I don't know on Zoom trials if the courts are providing any type of similar video feed. And not to suggest that there was anything particularly, brilliant or special about our, openings or closings or anything else that went on in trial. But one thing I was constantly mindful of is there are a lot of people watching this and learning how I try a case that wouldn't otherwise have access to this information. And, again, I don't mean to imply that there's anything particularly noteworthy, but, I think we all would agree that having seen our opponent try a case gives us a lot of insight as to how they try a case. I mean, if I were to try a case against Keith Bruno again, I now know things that I didn't before and help me better prepare my defense in light of that. So it's just, again, I mean, I think the benefits certainly outweighed that aspect, but it was, I mean, for instance, I'm sure that Nick Rowley was watching this trial and then advising Keith, as any one of us would, if we had that opportunity. But, he then had the benefit of Keith attending when Keith wouldn't, of Nick attending when he wouldn't have, had there not been for a live feed. So anyway, all's well that ends well, but just something to keep in mind if you end up in that situation. And again, wouldn't have done anything different, but it's just, it's an inherent issue with that type of access to the trial.
And the benefit to both Nancy and I is that now all of the plaintiffs' lawyers who were watching are scared to death to go to trial against Michelle and Joe and Levi and Matthew.
Uh-huh.
Yep.
Scared to death. Just quivering in their boots.
That's actually a nice segue to one of the other truly scary moments in the trial. I said there were 3 kind of medical flare-ups. I'll move on to the second one. So we had an injured plaintiff, and this is, I don't think, unique to the COVID era, but the plaintiff, they kind of wanted to hide him. And if they're listening, I would tell them that directly. I think they thought our best case is if the jury doesn't see him every day. And we've seen a trend of that in other cases, stroke cases, they have kind of a catastrophic injury, some catastrophic things they can emphasize, but the day-to-day, I mean, if they're seeing him walk in and out of the courtroom every day, that kind of, I think, lowers the value of the case. So they kind of, I think, were keeping him from the courtroom. He showed up one day and was able to testify in very detailed terms. This is a case where he was claiming he had a memory loss about, growing up above his, grandmother's bookstore and the section of the bookstore he lived over, and quite detailed memory, long-term memory. And then, interestingly, when the defense started cross-examining him, he clammed up, and we had to kind of finish early for the day, and so he had to come back a second day. When he came back the second day, he walked into the courtroom with a bag that we later learned was a vomit bag. And, there was something in the bag. And so we had to take a tactical pause. We did a sidebar with the judge, and we said, we didn't realize this was a vomit bag, number one. Number two, we didn't realize there was vomit in the vomit bag. So we kind of addressed our concerns to the court about, given that this is an airborne disease and he's now sitting within 12 feet of the closest juror, maybe we don't want to have him on the stand right now if he's not feeling well and thinks he needs to come in. I think it was a little bit of a show. I think it was a prop, and I was relieved to see the judge take action. And he said, here's what I'm going to do. I'm going to order the plaintiff to go down to the local, the county health officer. They've got rapid COVID tests. And I'm going to make his mom get one too, because she drove him here and she's on the witness list for tomorrow. And so the judge ordered both the plaintiff and his mother, who was a witness the next day, to go get rapid COVID tests, which were negative. And that was the second kind of medical flare up of the trial.
Levi, what was the third?
I'll let Michelle handle the third. I think she delivers this. And I'll go ahead and defer to Michelle here.
I'm not remembering.
Oh,
We're talking
okay. Well,
Michelle Snifflegate.
Talking about Snifflegate, yeah.
So I don't remember who the witness was, but Levi, I must have been. I know it was in our case because it was later
Yep.
in the case.
The last witness. It
Oh,
was
okay.
the last
Okay,
witness.
last witness. Levi is doing a direct exam, and I mean, and mind you, I mean, we've all been pretty sensitive to anyone who's coughing and Levi starts just sniffling. I mean, it's like clearly he needs a tissue and he needs to blow his nose, but he's sniffling. And I'm sitting there thinking, oh my God, please stop sniffling. What are you doing? And all of a sudden, Judge Baisden goes, stop. Jurors, you need to be excused. He basically rushes them out of the courtroom. Now, honestly, I wasn't thinking he was catching on to what I was catching on, but he was. And he said, in a weird kind of way, Mr. Larson, seems like maybe you're not feeling very well. I'm hearing you and I haven't heard you before sniffling. And I'm concerned and I'm worried about moving forward. And I'm just thinking, oh, you got to be kidding. You've got to be kidding.
No.
And Levi kind of didn't even know what to say because he didn't realize he was doing it. Says, well, I went for a run this morning. Maybe that explains it, but I feel fine. And not much more than that. And he turns to me and he says, Ms. Atkins. And I'm like, what? What do you think? I said, oh, I think we're fine. Let's keep moving. And then we all said, yeah, let's move along. And I thought, don't you sniffle one more time. And all was good.
That's pretty funny. Thank you for that. Levi, I want to ask you regarding closings and how plaintiff handled damages or was asking for damages. What strategy did he use?
I'm sorry, Noah. I want to answer that question, but I did want to work this slide in about the stipulation for remote testimony before we move into the closings. So this was something that we borrowed or stole from King County Superior Court, was requiring the language basically in an order for their remote witnesses. And so we borrowed this, proposed it to Lee. He agreed to it because we wanted some assurances that, if we were going to have witnesses, that they were going to have, the basic things so that they could testify in a way that would not interrupt trial. And we're just, I've highlighted the one here. They ensure they have sufficient hardware and internet access. And this was actually, we borrowed all of the paragraphs from the King County order, just threw them into a stipulation and then had the parties sign them. And it was, it's like, okay, everybody, if you're going to call a witness via Zoom, we're going to abide by this. One thing that happened in our trial was they called, in the plaintiff's case in chief, they called a witness that appeared with a cell phone in a car. And so I felt like that was actually a violation of the spirit of this stipulation, even though it technically didn't say, hey, your witnesses can't testify under oath in like a formal court setting from their car. But I think it served their purpose as well, because it was a witness that they kind of wanted to make look unprofessional. That was one of their themes in the case, was that we shouldn't have relied on this rehabilitation center because they weren't licensed medical professionals. And so then he calls a witness, his own witness, that testifies from a car. And so I would just say, for those of you outside of King County, if you're preparing for Zoom testimony, I think King County's order was a great jumping off point. I would add a specific additional paragraph saying this witness will testify from a room with no other occupants, comma, not from a car. And I mean, you would think that you wouldn't have to specify that, just the level of decorum that we would expect, you know, given that somebody's going to testify. But I mean, the appearance from the car was offensive to the jurors who are there taking this process seriously. And in this particular case, it played in the plaintiff's theme that this, you know, help this witness from this rehabilitation facility was not a professional.
I might even add some, I mean, I would definitely, I would say that, any remote witness should be testifying from an appropriate location, and then maybe give examples of what that would be. I also, if you could, and a little bit tougher, but I'd also say something about attire, because the other witness from the detox facility, who they also wanted to make seem like an incompetent witness, which quite frankly, they did a fairly decent job of. We've got one testifying from the car, and the other who's wearing, I mean, I can't remember what he testified twice. He was wearing, I don't remember the first day, but it was very casual, but nothing too bad. And then the next day, Joe, he shows up with this sweatshirt, and what does it say across it? I mean, was it Jordan or something, but it was just like, you've got to be kidding. Who would ever show up to testify at a trial, even virtually, wearing this athletic sweatshirt thing? And it just played so well into their theme of, and in fact, Keith Bruno in his closing said, well, you saw these people. I mean, literally said, you saw these people. Are these people you would ever trust to do anything well, let alone help facilitate the detoxification of a patient who was known to have prior problems with alcohol withdrawal? So I will never know whether they planned it that way, but it certainly worked in their favor in the moment.
I want to get to closings, but also before the taking witnesses over Zoom, I wanted to also, when we got to the defense case in chief, we had designated some trial testimony. We actually, I mean, we had a witness that passed away due to COVID. We had another 2 witnesses that actually ended up getting COVID that ended up testifying remotely. So I mean, it was, the pandemic definitely was a large undercurrent in the case, because we had the witness was out of county anyways prior to us finding that they had passed away. We had a plan in place that we were going to designate their testimony. We're going to have Matthew read it wearing a suit and tie, not an Air Jordan jersey from a car. And then Michelle was going to question him. So I don't know, Matthew, if you want to share that experience about kind of playing a witness in this Zoom era.
Yeah, sure. No, that was an interesting process. So we had planned to do the witness the day before. I had driven out to Port Angeles to do it. And due to motions practice and another couple other things, I ended up driving back to Seattle and testifying via Zoom from my office. And Michelle got to question me. It was an interesting interesting witness exchange, because in the original deposition, a lot of the questions, I was the person questioning the witness, and then during trial, I was answering my own questions. So I was sort of playing both sides of the role there. But I really wanted to compliment Noah and his team, and also Michelle. It was actually quite painless. I could see Michelle well. I think she could see me on the giant screen. We could hear each other quite well. And it was actually really great in that I could have the transcript up on my screen side by side, so I can be looking the jury in the eye while I was speaking. And just, instead I was looking at the transcript. A couple times I got a little bit tied up because I'm trying to scroll through it and, figure out where I was. In fact, Mr. Bruno, he called me out once. I tried to ad-lib a little portion of it, and I said, okay instead of yes, and he jumped on me for that. But otherwise, I thought it was a great experience and a good use of that hybrid format.
All right. Hey, Levi, I'm still very curious to hear some more, and Michelle as well, about Keith Bruno's approach to closings and asking for damages. Did he ask for a number? How did he go about that?
Oh, tell them about the art, Levi.
Yeah, I would say just as a general theme, he, from the first words out of his mouth, were brutally honest. And then he continued to play that theme throughout the voir dire, the questioning of everyone. A couple things that stand out from Keith's closing. He at one point sat in the witness chair, which I had never seen before, and kind of reenacted from his perspective his client's state of mind. And that was interesting. I actually thought that was one of the more effective things he did. I had never seen a plaintiff's attorney do that before. He also used, it was clear, the compliment sandwich for Keith was his voir dire was one of the best I've seen. I thought that his opening borrowed heavily from prior, what looked like car accident cases. I mean, at one point in his opening, he had a video of a whiplash sequence that just kept going back like this. And it was on like a feedback loop. And it was like, this clearly has nothing to do with the facts of our case. I mean, he fell and hit his head, but that wasn't, I didn't think it was a very effective visual for him. He carried what I thought was kind of copying and pasting this smorgasbord from prior closings that they had done into this. And it's clear they have this model down, and I think it could be effective maybe in California. But he led with, kind of this corporate power theme. He had a picture of Gavin Newsom. Governor Newsom had recently been photoed eating at the French Laundry. And to the Clallam County jury as well as myself. I mean, I was like, I don't know how this has anything to do with what the folks in Port Angeles care about. But he led with that theme of, this corporate power, and you can speak truth to power. And then it was kind of a formulaic roll into the damages. He had a photo of a man. Let me see if I can pull it up when Michelle starts talking. He had a photo of a man who was at the door, and there was like a light. The door had light coming through it. And at the break, Donna Davison, who I was working with from Olympic Medical Center, and her team, they said that is the cover photo from the film The Exorcist. And so we kind of got to laugh at that. And the point he was trying to make was, look, had Aaron gone back in time and Aaron was the plaintiff, somebody knocked on his door and said, I'll give you a suitcase full of $10 million. Would you take it if you then had to suffer this traumatic brain injury? And so he wanted to use that picture as a way of kind of making that point. He would argue his client wouldn't have taken this suitcase full of $10 million. And getting to know this plaintiff over years of litigation, I wasn't so sure about that. But I'll pass it on to Michelle if she had any specific comments about the damages arguments.
So then he had two other approaches that stood out to me. One was, and I think it got mixed reviews. I actually, it was a little creepy, but I actually thought it was somewhat effective. I think maybe Beth didn't agree. But I think what he was trying to do, what he didn't want the jurors to do was to really think about Aaron Brown, because he said over and over again, he's an alcoholic. He's always been an alcoholic. He'll always be an alcoholic, and you're going to think what you think about that. And I don't remember, but almost borderline disparaging his own client. So I think in closing, he was trying to take the jurors to a perspective that wasn't thinking about Aaron Brown. So one of the things he did was to say, I've got a son, I've got a young son. And if, I can only imagine if he saw Aaron Brown on the street. So one thing you should know, and one of the biggest things I think we were concerned about is, so one of Mr. Brown's surgical procedures was he had a craniectomy, and that his synthetic skull flap the skull flap that they placed the first time became infected. So they had to remove the skull. So literally we had photos of him where it looked like it had been photoshopped, that he had like almost the entirety of this side of his head just gone. And so I know that going into trial, that was our biggest concern, is that those photos were so inflammatory that could that get them over the threshold. So anyway, the theme in the closing was Keith talked about what his young son would be saying and thinking if he saw Mr. Brown on the street. Daddy, what's wrong with that man? Daddy, something very bad happened to that man. Daddy, who did that to that man? And Beth's laughing. And I think I'm making the point that she's right and I'm wrong, that it wasn't very effective, because it was kind of like that, but from Keith Runo. I don't know. I thought it was interesting. And I don't know. I think it did what he was intending. Was I was thinking about his son and not about Aaron Brown as much. The other thing was that, and I think other people have seen this done, is he put up a picture of a pot, a very, very valuable pot, a piece of art that he said, this pot is worth, I don't remember the number, $80 million. A pot, a piece of art, a thing is worth $80 million. And that was, of course, to set the stage or to set the threshold for. So when I asked you for whatever he ended up asking, that's nothing, because if a pot is worth $80 million, what is Mr. Brown's life like, to walk around with a half of a head and all that he's gone through and all that he will, that's nothing compared to the $80 million pot. So
I thought Keith's comment about his young child and saying, who hurt that man, Daddy? Someone hurt that man, Daddy, or whatever he was saying. I thought that was just really obnoxious. It didn't play very well after the third time he called it Port Angeles after being there for 4 weeks. So.
Oh, man.
Now is Klein moved to Port Jefferson?
Yeah,
So
I think it was.
what do you got here, Levi?
Well, this is the photo, everyone. This is the photo from this is the photo you used, and it's just right from The Exorcist. Yeah, I guess one other just final comment on the damages, and thanks everybody for your time. I'm sure Michelle and Joe and Matthew and Beth and Nancy and I will stay here and share war stories all day, but he did do something interesting, just to plant a seed if you're going against these guys. We did not pursue a contributory negligence theory. He wanted himself to add Aaron Brown to the verdict form so he could apportion some fault to his own client. And we weren't really prepared for that. They hadn't proposed that in their jury instructions. It really came up at the 11th hour, the night before. And then the next morning, of all the things that he wanted to really persuasively advocate in front of the judge, he had this very strong position that his client should be on the verdict form and he should be able to, attribute some percentage of the fault. We prevailed in keeping that from happening. We looked at the jury instructions and some case law that was pretty straightforward on that. But it was a first impression for me. I hadn't seen that before, and it didn't stop Keith from putting the verdict form up, even though his client wasn't on there, and saying, I wish my client could be on here because I would apportion some to him. So just wanted to share that.
Yeah, it was definitely a novel concept, and it went along with what he was telling the jurors all along, which was, he recognizes that his client has some responsibility in all of this. It did take us by surprise, and we weren't anticipating it. And the judge was this close to letting the jury apportion fault to him. I don't think it would have made a big difference, but it definitely worried us quite a bit. Luckily, the judge did end up coming to the right decision, but that was interesting.
All right, we are right at the hour here. Wanted to see if Beth and Nancy, any last thoughts?
Yeah, I just say kudos to everybody who was involved in this and managing all of the tech issues that came up. There was some feedback issues. There were issues with the live stream on certain days. But everybody did a great job of getting the information out there. and addressing problems in the moment as they came up. Sorry, Mike. But kudos to everybody, and the attorneys, you all did a great job.
Thanks.
I would echo that, and thank you to Hunter, who was out there from Noah's group with us every day, troubleshooting and working on the tech issues for us. Thank you to the attorneys, and fantastic job, everybody.
Thanks.
If I can have one final, both ironically, our staffs had shared out with our mothers, unbeknownst to us. I don't know if Michelle knew this, but at the morning of the closings, this is it. This is the big event. You're a trial attorney. This is what you live for. And then the judge is saying, "Excuse me, who is this that's up on the screen right now?" Well, at one point it was Michelle's mother, which was, a little funny and embarrassing. And then at another point it was my mom, and they were both they were both acting exactly like you would expect your mothers to do, all smiles. And it was, I think, a bit of levity to the end of a long, well fought case. So thank you everyone for tuning in.
Thank you, everyone. All right. Have a good weekend.
Thanks.
Thank you very much.